In this episode of Net Lease TV, we interview Tom Onder of the law firm Stalking regarding the potential pending Rite Aid bankruptcy and options for Rite Aid landlords. We hope you find this episode informational. Hey, Thomas Onder, welcome to Net Lease TV. I have the privilege to speak with Thomas on a very timely subject, what's going on with Rite Aid. Thomas is an attorney with Stark, and he has a good handle on bankruptcy. Chapter 11, we're going to dig into that with Thomas. So Thomas, how's your day going?
Pretty good, Chris. Pretty good so far. Just waiting to see if Rite Aid files for Chapter 11 bankruptcy or not.
I know, we like to deal with positive things, but you got to know the mechanics. If you're a landlord of a Rite Aid right now, you really need to know the nuts and bolts and what are your options. Correct?
Absolutely. Absolutely. And what's funny about it is, there are some positives to this because there could be some landlords out there that have under market leases who may have an opportunity to get back their leases and rent out at a higher market value.
So there's a silver lining there. There's still some positivity in there for the landlords out there. So tell me a little bit about your firm Stark. Where are you guys located?
Sure.
And is bankruptcy kind of a focus of yours? Because I know I saw Carly Iacono had posted your firm on LinkedIn, and that's kind of how I learned about you actually on LinkedIn.
Yeah, so I'm with Stark and Stark. We're based here in Hamilton, New Jersey, right outside of Princeton, between New York and Philadelphia. We've got a little over 100 attorneys, and about 20 of us or so handle specifically real estate development issues, whether it's anything from collections and evictions, leasing, buying and selling of properties, eminent domain, and then also my specialty, which is protecting landlords and owners in retail bankruptcy proceedings. Myself, I've got a little bit of a background in bankruptcy. When I got out of law school, I clerked for 2 bankruptcy judges and had a really nice opportunity to see how the bankruptcy process works and see from on the other side of things, from the court side of things, how everything works. For the last 20 years, I've been here at Stark and Stark, and one of my specialties has been bankruptcy work for shopping center owners and developers, and kind of watching to see what happens with potential bankruptcy proceedings like Rite Aid.
Okay. What are some of the other tenants you've dealt with that have gone bankrupt that you've had to work with landlords?
Sure. So most recently, we've been involved in the Party City bankruptcy case. Party City actually emerging from their Chapter 11 case. They've actually reorganized, and it's still an active company. The David's Bridal case, A&P bankruptcy, EMS, Radio Shack. Any of the larger bankruptcies that shopping center owners or developers have kind of gone through with retailers over the last about 10 years or so, we've been involved in.
Interesting. It's interesting. So this is definitely timely for those landlords that are kind of scratching their head. What do I do now? So let's talk about Rite Aid a little bit.
Sure.
From what I understand from a couple articles I read this morning, they have like 3.3 billion in debt. They have 2,200 locations. They plan to close 500 locations. That's about 22% of their 2,200. They're on the NYSE, and I believe that they may get delisted. So if you have any insight into that, once they drop below 1. Right now, their stock, I looked at their stock this morning. Today is Monday, October 9th. Their stock's at about 64 cents. It's actually up this morning. And they have a shareholders deficit of about 947 million, Tom. So the other thing that I read is they have an FHR rating 21 out of 100. And whenever you're 21 out of 100, the article said it's a good probability you may go bankrupt.
Yeah. So I think with all those statistics you got there, that it really does look like they're going to probably be filing for either a Chapter 7 or a Chapter 11. At least with all the chatter that we've heard, they most likely would be filing for a Chapter 11 bankruptcy, which is the ability for the debtor to maintain control and try to reorganize. Sometimes that winds up being really a sale of all assets, which we kind of think would occur here, where the debtor stays in control and is able to sell the remaining leases and other assets that they have. They could wind up reorganizing. However, all indications seem that this would probably more likely be a sale of most of their assets.
So you said sell some of their locations. Would they assign those leases to other retailers? Is that a strategy they could do?
Yeah,
And is
so
that very common?
one of the nice things about the bankruptcy process for debtors or for creditors is it allows one forum in which the
Okay.
debtor can come to court and try to, in this case or in other cases, sell off assets. Because if they don't have one forum, what you have is hundreds of locations around the country that the debtor's trying to get out of eviction proceedings, collections proceedings, or other things. And this one forum in the bankruptcy court allows the debtor to consolidate everything and to try to make sure creditors are taken care of according to their different priority. For myself, I deal a lot with landlords. And so landlords really want to know what's happening with my lease. Am I getting it back? Is it being sold? Is it being rejected? And what do I do with the money that I'm still owed? So the first thing that we tell landlords, if a debtor does file for a Chapter 11 bankruptcy, is absolutely get your accounting in order. You want to make sure that you know what is owed as of the date of the debtor filing. And what's important for that is that when the debtor files their bankruptcy petition, you as a landlord or trade creditor have the ability to file what's called a proof of claim. And what that is, that's a right to payment. If you don't file that, you could wind up losing out on certain rights and even payment. So that's the very first thing that you really need to know about when a debtor files for bankruptcy. The second thing is for the landlords, what are they doing with the lease? Are they keeping it? Meaning, are they going to assume and possibly assign it to somebody through a sale? Or are they going to reject that lease and just give it back to you? If they're going to reject that lease, you just want to know when they're going to reject it, because if they haven't done so before the filing of the bankruptcy, you may be entitled to a payment of a portion of a claim called an administrative expense claim. So it's very important to know, has the debtor given you the keys back or possession as of the date of the bankruptcy, or do they still have it? Have they not given you the keys? Have they not given possession back? One of the interesting things here is with Rite Aid, because it is a pharmacy and there's going to be drugs and other items that are there, they're probably going to have some procedures in to make sure that those drugs and other items are taken care of so the landlords don't have to deal with them. That's really important for the landlords because you don't want to be left with medical information or other things that could be personal identifiers of customers that the debtor has.
So Tom, say that you have a tenant and they stop paying rent, and then they instead of rejecting the lease like a year later, we're going to assume, we're going to do the election assumption. Can I go after them for the rent that they didn't pay?
So that's really interesting, Chris. So when a debtor files for bankruptcy, they generally have 90 days to decide whether they're going to assume or reject the lease. They then
Okay.
have the ability to file a motion and get another 120 days without really any issue by the court. So altogether, they get about 210 days from the filing to decide whether they're going to assume your lease or whether they're going to reject your lease. During this period, though, the debtor has to keep you current. So if they were to file, say, within the next couple days, generally the first payment that they have to make is that following month. So say they file later this week, the November rent would then have to be due and paid. If it's not paid on November 1, then the creditor, the landlord, has the ability to go to the court and say, hey, I'm not getting paid. This isn't what is supposed to occur under the bankruptcy code. And they can file a motion for what's called stay relief to be able to go back to state court to try to evict the debtor. During this time period, the landlord would have a claim from the time of the filing of the petition until they actually got their space back, which is called an administrative expense claim. And that's generally paid ahead of other creditors. So it's very important for the landlord to know, one, when the debtor files, if they file, are they still in the space? Two, are they going to be paying that next month's worth of rent? And if they're not paying that next month's worth of rent, then to go forward and to enforce their rights to make sure they get their claim filed, and also so they can get back to state court if necessary, to go ahead and evict them. A lot of times like this, though, when there's a Chapter 11 case, if the debtor for some reason is not paying that next month, you can usually try to work something out with debtor's counsel to be able to get an order saying, yeah, we're rejecting the lease by a certain date. This at least gives the landlord some certainty that they have possession of the space and that they can go forward with any reletting options or to market the place.
Let's say that they do reject the lease, and the landlord has another tenant in tow ready to lease, and they have to have that broom finish and ready to go for that other tenant, and the tenant that went bankrupt just leaves the place kind of in a shamble. Can they go back to the lease, or because that tenant uh, rejected it and has gone bankrupt, is there any recourse for that landlord to say, hey, you left this place, you just kind of abandoned it, and now there's fixtures, furniture, racks in here, and you didn't take everything out like you were supposed to per the lease. Is that something that occurs with bankruptcy?
So that's a really interesting question, Chris. So number one, debtors usually try to file a motion for abandonment of property. And what they do sometimes is they'll say, listen, when we're rejecting a lease, whatever lease it is, if it's rejected, anything that's left there is going to be just left there. Now, as a landlord, you can try to fight that a little bit and push back, but generally courts will allow the debtor to leave certain things like shelving and other items. What the courts usually won't allow is the debtor to totally trash the place or leave it in shambles. So it's very important that when the debtor files a motion or procedures for rejection, you have your counsel take a look at what that proposed order is and either get on the phone with debtor's counsel or file some type of opposition to that. Your lease, although it controls, if that order is entered and you haven't filed any objections or you have not worked out any kind of side agreements with the debtor, you're going to be stuck with that order. A lot of times, debtors will work out what's called side letters or side agreements with landlord's counsel who file certain oppositions to motions, where basically they'll say, listen, we'll make this agreement and we will take care of this. We'll remove this or we won't remove this. But generally, a debtor is going to be able to leave certain items, again, such as shelving and stuff, to the landlord. The landlord, though, has the ability to file a claim against the debtor. As I talked about before, there's a pre-petition claim from the date of the petition prior to the bankruptcy. There's an administrative claim, your second claim, which is from the date of the bankruptcy petition until they leave. And then there's a third claim, which is, we call it, it's a post-petition rejection claim from the time that they give you the keys and leave until the end of your lease. And there's a formula that the bankruptcy code provides, but it's very important that landlords have adequate counsel that understand how to calculate those claims and get them filed on time. Because if you don't file them on time, you could be out money.
So Tom, I know that you've already talked to some of the Rite Aid landlords. I think you mentioned when I first spoke to you. Do you think it's a good time, even though they're not, I don't think they've formally filed, correct? They're not formally bankrupt yet. Is that correct?
But before we jumped on Net Lease TV, I double checked to see if there was a filing, and I did not see a filing yet. But I am anticipating that there will be one soon.
Okay, so should they start to contact you now to get things organized and to get
yeah, so I think it's vital. Yeah, I think it's vitally important for landlords to kind of get their ducks in a row, now, rather than waiting until the debtor files. Because number one, when a debtor files a bankruptcy, there's a lot of pleadings that are filed initially called first day orders. And a lot of those first day orders will have things that can affect the landlord's rights. It's really imperative to make sure that your landlord is protected and is able to convey their issues to debtors counsel, quickly. Additionally, you want to take a look at your lease to see, if you're allowed things like attorney's fees. Generally, you'll only be allowed attorney's fees in a bankruptcy case if you have specific language that's in the lease. And you want your attorney to be able to tell you now, rather than after you spent like $10,000 with them, whether you're going to be able to recover your fees or not. Additionally, there could be other issues in there, co-tenancy issues and things that you want to take a look at. Because again, with this case, and again, they've not filed yet, but we're anticipating that if they do file, that there's going to be a sale of assets where the debtor would go by and assume the lease, and then they would assign it to somebody through a sale process. And it's very important for the landlord to understand what are the co-tenancy provisions, what are the provisions specifically with the debtor that you had when you first entered into the lease with them. One of the things that the landlord has, which is a kind of a very powerful tool, is they have the ability to assert adequate assurance, meaning if someone is going to purchase the lease and become the new tenant, they should be adequately assured about that new tenant, that new tenant is going to be able to operate, that there are not going to be any co-tenancy issues or anything. Now, in this case, there's most of the Rite Aid locations are single assets. But again, you want to take a look at your lease and your contract documents before this filing and really consult with counsel now, so you've got all your ducks in a row.
Is there anything, Tom, that you can do, start to research how the store was doing? Maybe your rent to sales was amazing. Your specific store was an amazing store, and it's a huge, benefit when you go to talk to Rite Aid if they're going to assume that store as far as negotiating, or does that come into play ever? Is Rite Aid out to this landlord and say, your store is one of the good ones. We really like it, and we will assume it. Maybe if you give us a little bit of a rent reduction, does that ever happen or no?
So that does happen with debtors when they want to continue on with the operations, even if they want to just do a sale process. So landlords should be cognizant that the debtors are going to probably come back to them, and prior to them saying whether they're going to assume or reject the lease, the debtor could say to the landlord, listen, this would be really great if we could get a reduction in rent. And it's really incumbent upon the landlord to make that business decision whether they want to have some certainty that the debtor or some other entity is going to operate there. It doesn't necessarily mean that the debtor is going to continue to operate. So landlords should be wary of any requests for any kind of rent reduction, what they're going to get from them on that. And also, again, consulting with their counsel to see whether this is a really good strategy or not to operate. But we've had in the Party City case, the David's Bridal case recently, we had the debtor come back to us for some of our landlords, and they've reached certain agreements with the landlords to do just that. And again, it was for certainty that they would know that the leases would be assumed.
So let's say that they do assume the lease and the lease change. Does the lease change? Do they do like a modification to the original lease? Is it a new lease? What happens? Who pays for that? Does the tenant Rite Aid pay for that? Does the landlord's legal pay for it? How does that work?
Sure. So that's a really good question, Chris. So the lease, what it's going to basically be is you can consider it an amendment of the lease because you're going to have an order that says, hey, company XYZ purchased this at the bankruptcy sale hearing, and they're now your new tenant. That's really going to be your amendment to the lease, but it's really just going to change the name of the entity from Rite Aid if it goes through a sale process and assigns it to somebody else that you accept and that the court approves. Everything else in the lease will still stay the same. So your provisions for, what the rent's going to be, your provisions for the premises location, that's all going to stay the same. The only thing that's going to change is the name of the entity and probably like notice addresses.
What happens if they sell it, the debtor sells it to another tenant and another tenant goes into the building? Will the lease change in that? Am I giving you too many variables there, or
No. That's pretty much the same the same
scenario?
structure as we just talked about. Because in this case, what we think is going to happen is that the debtor is going to have a mass sale of all of their leases. And again, if they go through that, what they will be doing is they will be assuming the lease and then assigning it to a new entity. And so that new entity could be another pharmacy that comes in and buys up a bunch of stores. That new entity could be a new entity of Rite Aid. Whoever it is, they step into those shoes as of the date of the sale and purchase.
Do you ever get a circumstance where a tenant goes bankrupt and another company buys that company, and then all of
Yes.
a sudden it changes the whole situation? And
Yes. So what happens is there's a thing that's called a stalking horse. And
okay,
sometimes in the bankruptcy process, you'll get a company that comes in and says, listen, I want to buy a number of these assets or the majority of the debtor assets. And so that stalking horse will sometimes come in and make a large purchase and take over the basically the assets that are there. So all of the leases. What they'll sometimes do is they'll work with the debtor to have certain leases rejected that they don't want it to take over, and then they in fact become the new entity.
is that what happened with like Radio Shack and Toys R Us? Did they have like a stalking horse that came in? Because I think they started it up again. The company actually is going again, or did
Yeah,
they
so
just
I think with Toys R Us, I believe
okay?
that there was an entity that purchased the IP, so the
Okay.
trade name and things like that.
Okay.
Majority, I believe, most all of the Toys R Us stores and the entity that was part of the Chapter 11 that they've all closed. So I believe that there was an entity that bought the naming rights of Toys R Us, and now I think there's. I read last week or the week before that there was a maybe about 20 locations or so that they were planning on opening up across the United States, but a much smaller footprint than what they had before.
Do you think Tom Walgreens, CVS could come in and vulture, pick through the Rite Aid locations, and
Oh,
maybe
absolutely,
try to
absolutely.
buy some of those
Yeah,
locations?
absolutely. I think that you're going to see a number of their competitors really take a hard look to say, okay, is this a location that would benefit us or behoove us to try to take a shot at? And they could pick up, anywhere from half a dozen stores to many more. Again, it all comes down to a business calculation for them whether this is good or not. A lot of these locations are in high traffic areas, and so there is a benefit there for some of these competitors to possibly try to take over the leases.
So now let's say I'm a landlord, Tom, and I have a loan. I have a first loan on the property. I was getting rent from Rite Aid and paying my loan with that. What should kind of be my first step with the lender, to start to have some dialogue with them on the fact that, I may not be getting rent here in the near future. What's my next step? Should they
So,
contact someone like you? Do you represent
yeah,
clients in that regard?
yeah. So our office, we do represent landlords who are in that situation, regardless whether they contact me
Okay.
or they contact somebody else. They should really reach out to counsel now, as we talked about before. One, just to plan out, how the bankruptcy, if they do file, is going to take
Okay.
place, what their strategy is, and then two, do they need to alert the lender? There's probably certain covenants in their documents that say whether they need to alert the lender or not. It's always a good course to really kind of strategize what you need to do so you're not in default with any of your obligations.
Sure. So I know we've talked about Rite Aid, but a lot of the landlords own these, the franchise fast food properties.
Hmm.
With those, sometimes you'll have several guarantors on the lease. Um, what would be your first step there if you're dealing with a smaller tenants? You try to do a background on like a background check on all the guarantors to see, who has the most money, or let's say they haven't totally gone bankrupt, but they've stopped paying rent and they've vacated the building or it's gone dark, and you may want to, try to go after the rent for the remaining lease term, but you're also fearful they may go bankrupt. Have you ever had that type of a scenario with smaller tenants?
Yeah, so we represent a lot of owners, developers, and landlords who sometimes will have that situation occur where they're not getting paid. They think that maybe the tenant, or franchisee who owns a number of locations may be going bankrupt or are having a hard time. And so one of the things that we'll usually do is we'll request, from our landlord or our owner to kind of take a look and see whether it looks like from the financial reports that they previously had from that tenant, whether there's really anything to go after. In a bankruptcy, a Chapter 11 bankruptcy or a Chapter 7 bankruptcy, there's no preclusion from going after guarantors if the company entity filed for bankruptcy. So we recently had a case within about the last 6 months where there was an entity that filed for bankruptcy, but the guarantors did not file for bankruptcy. So we proceeded against them in state court and were able to get a judgment against those guarantors and are now attempting to collect from them. Whereas the bankrupt entity, we weren't allowed to go after because they were in bankruptcy. But again, it's very important for landlords, when they're having problems with tenants, number one, send out the default letters and get the process started, because the tenant may wind up contacting you and trying to work something out. But if they don't, you really want to get the ball moving on what your rights are as a landlord, whether that's proceeding with a collection, eviction action, or even, to protect yourselves in a bankruptcy.
So Tom, how can a landlord out there that owns a Rite Aid or other property that are having problems with their tenant or the potential bankruptcy, how should they contact you?
So I'm always available. I'm always available on the web. You can contact me at Onder, that's TONDER, at stark-stark.com. Or you can give me a call at 609-219-7458. We represent landlords, developers, and owners throughout the country. So whether a debtor files in Delaware, if they file in Michigan, if they file in New York or New Jersey, we can usually represent you. And for some reason, if we can't represent you, we'll find somebody, one of our friends throughout the country, who probably can.
Let me ask you this. Do you normally give them like a free consultation just to talk about their situation? And then do you do a retainer? What do you charge per hour? And like, is it really variable, the total cost in a bankruptcy type situation for a landlord, or you charge
Sure.
an hourly fee? Is it capped?
Sure.
What does it normally cost?
Sure. So generally, we're happy to talk to any landlord who would like to discuss the bankruptcy case, free of charge. I'm happy to jump on a call and kind of see where you're at, what issues that you have, and then if you'd like to retain us, we can provide you a fee agreement, and we usually require a retainer. Our fee committee requires that. We don't really try to advertise what those costs are and everything. But we're generally reasonable, a lot more reasonable, I think, than some other firms that are out there.
Okay, awesome. I want to thank you, Tom, for kind of going through the nuts and bolts of what a Rite Aid landlord, what another landlord should do if their tenant is kind of stumbling. I think this is really timely information. And thanks again for being on Net Lease TV. Thank you, Tom.
Thanks, Chris. Good seeing you.